see exactly on screen how's everyone doing. It's Thursday, which I did not really expect trial to be, well, not done, because there's still more to go, but we got some audio and roll up. 1 second.
Can you hear me now? No, yes, no. All right, I'm going to have to check what the heck I sounded like because I have no idea what was going on there, but apparently it sounded robotic. Neat. And then the audio dropped out. So, yay. All right, so let's try this again, shall we? So today was a short day, and in this short day, the defense managed to blow up what looked like it was going to be a really good theory for them, but then that kind of exploded on them. So there's that. And then there's they spend a whole lot of time arguing about stuff that I don't know if it's worth covering because how do I put this? The defense spends ages arguing for we want to tender certain evidence. And then they finally get permission to tender the evidence. But the judge is like, if you do this, then the prosecution gets to respond and gets to tender similar evidence. And they're like, then we're not going to do it. So they spend like 45 minutes on this or more. But all right, let's see what's going on here, because I just put it this way. I thought I got good sleep tonight until I tried watching today, and then I was like, I hate everything. And that had me I just feel so tired right now. So yeah. By the way, I set a goal for a unicorn, specifically an electric unicorn. Okay, let's dive into this. I don't know. I shake my head a bit. We're going to take it up to 1.25. We are going to share the screen. There we go. All right. We're going to do this. So, let's dive in at the beginning because yeah.
Okay. So, it's up on the screen right now. So, it starts with Bates number state STATE 0335281. And this was produced to us before the state went through and updated the time. So this is on UTC time instead of mountain time.
Okay.
At some point in this case, and there have been so many supplemental, I think we're on our 10th exhibit list. I think we're, anyway, hundreds and hundreds and hundreds and hundreds of alterations and substitutions. But this is the one we got before they had changed the UTC time, which was confusing to everybody. And so they went back and redid that. This version, they had not changed it yet to mountain time. This is a consecutively numbered, Bates numbered document. There's no pages missing. This is coming from a Celebrite extraction of Eric's phone that was seized by Mr. O'Driscoll. We just found the Celebrite and extracted by Miss Gibson.
Can you show me the Celebrite?
Yes, sir. We can, and we're pulling it up right now.
very big file, so what I've done is I've emailed Katie the cover page, and then I'm working on the box download so she can download it.
Yeah. Forgive me. And this is a nuts and bolts question.
Sure.
Forgive my ignorance. I'm looking at one page that shows 3 text messages total.
Right.
Typically, these are a complete string that has a Cellbrite header. Where is that version of this text?
So not all of the ones we've introduced in this trial have the Cellbrite header. Only some of them, not all
I
of
don't know
them.
if is that true. I thought
That's
all of them had the
No.
Cellbrite header.
That is not true.
Hold on. Let's pause there for a second because I think that's how we've been laying foundation for the admission of them so far. Foundation.
Right.
Mr. Bloodworth, is my memory correct? Unless they came from, we've had CDR related metadata regarding text messages. We've had some non-bubble related or non-bubble depicted cell messages that have come out of other extractions. But in terms of blue and green bubbles, I thought all of them had a Cellbrite header.
Yeah, I believe that's right, Your Honor. If we prepared an exhibit that comes from a Cellbrite extraction, it has the Cellbrite header.
Right.
There's others where we just, we've got texts from other means. Somebody sent us, forwarded us text, right?
Right.
If
Screenshots, for example.
correct.
Yeah.
If it comes from a Cellbrite extraction, as best I recall, it has the Cellbrite header.
Okay. Ms. Nestor, I'll give you the record back here in a second, but it's also
So basically what is going on here is Ms. Nestor wants to bring in some stuff, and they're like, is this real stuff or not? So, yeah.
unclear to me, is this 3 text messages that we're talking about, are they part of a larger exchange that has already been admitted?
So these are all the text messages he had with Kouri on the day he passed, on the 3rd.
On the 3rd or the 4th?
He died early morning in the 4th. So it's from the 3rd.
Okay. These 3 bubbles are the sum total of their text traffic on the 3rd?
We have more than 3. There's, just a minute. There's a couple pages to it. It's the last set of texts that they, there's multiple, see, that's the 2nd page. And yeah. And that's the last text that they had between the 2 of them before.
Can you go to that one, please? Katie, can you blow up the 3rd one on that sheet? So, as I understand it, among other objections that the state may have, the first one is foundation, correct, Mr. Bloodworth?
Yes, so that's the threshold objection.
Right. And as I understood it yesterday, the foundation objection was this is not what it purports to be because the daytime information is inaccurate.
Well,
correct?
Your Honor, the state's question as to whether this is what it purports to be, the genesis of that is that I noticed that the time is not corrected. And I would expect for the Celebrate downloads that we have authenticated.
Now, can I just say, I think Scott's mustache has somehow gotten even more amazing. And I don't know how that happened, but his mustache is like more epic today than it has been on other days of the trial. So props to Scott's mustache, who is the real star of today, because Scott's mustache does some of the best lawyering of everyone in the room because they spend so much time arguing over bullshit.
And laid foundation for. The time change is baked in.
Consistent across the board.
Consistent across the board.
Right.
So the fact that this is still in UTC -5 instead of UTC -6 or 7 just caused me to question where this came from, which Celebrate download it came from. And I still don't know.
So that brings.
So he's like, what is this document? Where is it from? And yes, I just pulled this one up. Please send healing vibes or prayers for our sweet fur baby Chloe, who started chemo today. So if you've got the mental space to do it, pray for Chloe to have good results here. Because
Is there a version of this that has the?
That's what's on the screen right now.
And so if you would scroll through this extraction report and show me where it includes the portions that you want to use with this witness, just so we're all on the same page.
Just give us a second.
No
It's
problem.
very long, so we have to go right to it. Just give us just 1 minute.
No problem.
Oh, are you on a Mac? Oh, God.
I don't know if you could hear that muttering. Oh, are you on a Mac? Oh, God. And I'm sitting there going, this is a murder trial and you don't have your text sorted. Okay.
Our millennial has a Mac, so it may take a second.
Well, this discussion doesn't need to be had with
Our millennial has a Mac. Seriously, Nestor? Seriously?
me on the record in front of everybody. If you can have it with each other first and then distill down what the dispute is, if any, regarding foundation.
Yeah.
I understand there may be other objections that we have to get into.
And perhaps, Your Honor, we could work parallel while they're seeking out the foundation information. We could address, well, a couple things. I think it's hearsay, as best I can tell. These are conversations between the defendant and Eric Richins. The state's further objection is that it's beyond the scope of the direct.
Let's handle those one at a time.
Okay.
Ms. Nestor, regarding hearsay, your client's statements are hearsay if they're offered by you.
Right.
Eric Richins' statements are categorically hearsay if they're offered for the truth.
Right.
What is the non-hearsay purpose of these particular text messages?
So we are actually not interested at all in what is being said, and we could do an instruction to that, excuse me, to that effect. What we are trying to get in with this exhibit is a photograph that was sent on the day before. Technically, Eric died on the 3rd, and that was sent the day before. That is connected to the GIFs, whatever you say, that all got accessed the next morning at 8:30, which the state is making a big deal out of and mentioned in their opening and has called witnesses about it.
Provide a little more context. What is the photograph of and who is it sent by?
The photograph is sent by Eric to Kouri on the 3rd from when and there's been testimony that's come in that he was out there spreading gravel to make it look nice for the closing or whatever. And he sends her a picture of it while he's there before he gets home that night. That is one of the pictures that is connected to the GIFs that were accessed, the orphan GIFs, the next morning at.
I just want to throw pennies at them every time they say GIF. But so I am going to comment on Kouri Richins' choice of clothing. And I'm going to move myself in order to do it so that you can actually see what she's wearing. She is wearing one of the most strikingly attention-getting outfits that I have seen all through this trial. This is a really bright yellow. It's super, I'm sitting here looking at her right now, and it's causing eye strain. This is not what I want from a client in a criminal trial. I want my client looking boring as fuck. I don't want her looking I mean, if that shirt was any brighter, Scrooge McDuck would try to jump into it. So, this is too garish. Wear something a little less, please. Yeah. And I mean, this isn't a comment on, I know somebody's going to be like, oh, he's commenting on a woman's outfit. I'm commenting on the accused's outfit. Because, I mean, if I had a male client show up in a bright yellow top, I'd be like, seriously? Are you kidding me? So we are also opening the electric unicorn here. Why are you dressed like a misplaced lemon? What's going on here? So I just don't even know why she actually owns this shirt, because why would you own a shirt that yellow? Just in general, that it's a bad choice. It's just a really bad choice.
8:40 as soon as the police leave, and they're trying to make it seem like Kouri was celebrating he died with these happy GIFs. And it's connected because that picture was, the implication that's being made is that those GIFs were being sent or accessed or sent by or to Kouri the morning Eric died, when actually the picture that was also accessed at the exact same time came from the day before. So it doesn't mean that. And that's what we're trying to explain to the jury. All I care about is the non-testimonial section of the interaction that shows he sent a picture on the 3rd, and that's one of these pictures that was accessed with these GIFs at the exact same time, and it was sent the day before. And that's all we're trying to do. We don't care about what's in the bubbles. We can black out what's in the bubbles. I don't care.
Why are you?
So, like, I don't know. Is like, did Katie Richins get to pick the shirt for Kouri Richins today? Because
doing this through Detective O'Driscoll? Why didn't you do it through Mr. Kotradimos? I'm not sure Mr. O'Driscoll or Detective O'Driscoll has the ability to testify to any of what you just said.
Well, he testified that he reviewed Eric's communications the day before he died. He did testify to that.
Right, but this goes well beyond that and is far more technical.
All I'm asking him to do is say, did you see?
I mean, sometimes a picture could be a statement. Absolutely, it could. So, yeah.
He sent her a picture the day before. The rest of it we'll do separately.
But that's not necessary foundation for the argument that you're trying to make. This is a technical metadata-based argument that I understand why.
Her clothes are probably being picked out by her lawyers or her mom. And, like, it's not a good choice. If her lawyers pick this out, I'm just like, I don't know why.
Defendant believes it's relevant. I'm not suggesting it's not. I'm just not sure it's this witness.
I'm not going to ask him about any of the metadata. I'm going to say, did you look at Eric's phone the day before? Did he send this picture to Kouri? That's all I'm asking. Nothing fancy, nothing technical. He said he reviewed Eric's phone, that he looked at his communications. And we can even take out the metadata and just show the picture. That's all I
Without the
care
metadata,
about.
the picture is not relevant.
Well,
You need the date and time.
We have that. No. We
No, you don't have that.
do need the date and time, but I'm talking about the, I thought there was more information on the bottom of those things. And
Why are we doing this for Detective O'Driscoll rather than through another witness that can testify regarding the relationship between the file path for the GIFs and the file path for this photograph?
Because he reviewed it and saw it.
Because she wants to end on it, but also maybe because she didn't think of it, and also maybe because she doesn't want the other person to, she doesn't want the other person to know anything, because then they would respond.
I think he can testify to it.
You can't testify to any of the technical relationship that you're asking for.
Correct. And we're not asking for that. That's all we're asking him, is to say that the picture was sent the 3rd. That's all I need him to say. And he knows that because he reviewed it. So he's capable.
He knows what he saw. How
Right.
does he know that the picture was sent the day before?
Because it's on the face of it.
But then it's coming in for the truth, right? And so
But that's not testimonial evidence.
I agree. So if it's not testimonial and it's on the face of the text message, what difference does it make that Jeff O'Driscoll reviewed it? I'm not suggesting you can't get the evidence in. I just don't understand why it's coming in through this witness.
This is the witness we would like to bring it in through.
I don't know that this witness has foundation to give you.
I mean, sure, I'd like you to bring it in through Santa Claus, but I mean, Santa Claus might not be the appropriate witness. And like, also, you take that back. We elves do not claim Kouri. I'm in Montreal for the meetup without a meetup. I'm sorry, Lena. I'm sorry. I tried. I got told that we couldn't. So
The testimony you're asking for. What's the question you're going to ask?
I already asked him. I said, did you review Eric Richins' communications the day that he died? And he said, yes.
Okay. And then what's the next question you're going to ask?
Is this picture, was it involved in what he sent the day he died? That's all I'm asking.
You just want a yes or a no?
Yeah. I'm not asking him for
I'm
any
not sure that's
technical.
even dispute. Go ahead, Mr. Bloodworth.
Let's never come out before on any other witness.
So I just realized what Kouri's dressed as. She's dressed as an egg. She's got an egg outfit, because it's like white gray on the outside and bright yellow on the inside. She's dressed as an egg. Why is Kouri Richins an egg today? I don't get it.
Okay. But go ahead, Mr. Bloodworth.
I didn't have anything, Your Honor.
Okay. Is there any objection to him just saying yes or no to that question?
Yes or no to the question of, did he review Eric Richins' text messages from the?
I think that's already been answered. Yes
Okay,
or no.
yes. Then what's the follow-up?
Did Eric Richins send a picture as part of those text messages?
And so if
Detective O'Driscoll says, based on my review, he did, period.
I still don't know if that is sufficient foundation to admit this.
Well, I'm not sure it's going to be admitted. I just think they're trying to lay foundation, I guess. Did you want to publish the photograph, Ms. Nestor?
I do want to publish the photograph.
And tell me why the photograph is relevant?
Well, that photograph is already in as part of Exhibit 340, which
It's not in, but we've stipulated.
we've stipulated is coming in next. But I just want to show it's the same picture. That's it.
And forgive me, you're referring to an exhibit that hasn't yet come in
We stipulated to it. It's about to come in.
through.
O'Driscoll.
And what is 340?
It's the list of all the pictures that were accessed that morning at 8:35 a.m.
What,
Why don't we just do it in the reverse order then?
I can do that.
I mean, we can see on, I still think there's a hearsay problem. Based on counsel's explanation now, I also think there's a relevancy objection. The photo that we've been discussing,
I feel like there's a I am gonna die here objection just because, oh my God, get on with it. Like this is, yeah.
The gravel photo.
the gravel photo was not accessed at 8:39. It was accessed at 10:42.
Well, this is a foundation question, but the premise of the question Ms. Nestor is seeking to ask is, was this photo among the communications or sent by Eric Richins to Kouri Richins on March 3rd, right?
Yes, sir.
Full stop. I don't think that's fairly in dispute, right? And I don't think that's a hearsay issue.
I think publication's the hearsay. The fact that any photo was sent is fine. I think if we get into the specific photo that was sent, there's a hearsay problem.
Are you taking the position that the photo is a statement?
Yes.
Not sure that follows without additional context. Just
So here I would say that this photo isn't a statement because the photo isn't being entered for proof of the truth of its contents. It's being entered to prove that photos were sent. Yeah.
sending the photo it's evidence, it's a fact. I'm not sure it's a statement.
The statement is, I just dropped gravel at the Midway Mansion.
Well, I don't think any of that's coming in. It's just the photograph.
But that's what the photograph says.
I don't understand. Is there
No, the photograph is just a picture of gravel, right? So
text on the photograph?
No, Your Honor, but the defense has, the defense has, as part of their case, said that Eric Richins was into the Midway Mansion as evidenced by him dropping photo.
I want to come back to what I understand is being proposed by Ms. Nestor through this witness. Detective O'Driscoll, did you review Eric Richins' text messages with Kouri Richins the day before he died? Yes or no? I understand the answer to be yes. Did he send Kouri Richins a photograph as part of those text messages on March 3rd? Yes or no? Yes. Is this the photograph that he sent? Full stop.
Oh, I'm fine with that. The only, I think there's a third option. It's not yes or no. It's I don't recall.
Oh no, fair enough. I'm not telling you how to testify. I don't know what it'll say. But as long as you don't go beyond that, Ms. Nestor, and as long as you don't make any representations regarding time, date is fine.
Great.
Then we don't have a foundation problem. We don't have a statement that would be subject to the hearsay rule. I think the low bar regarding relevance is met in as much as the defense seems to be laying foundation or argument to come later regarding when images and file paths on Ms. Richins' phone were accessed. Any other nuances here, Ms. Nestor?
I don't think so.
Do you understand, do we have a common understanding of the limits of what you can ask Detective
Absolutely.
O'Driscoll without drawing another objection?
Absolutely.
Do you have an image of just the photograph?
I do, but I think if it's out of context, he won't, it's too hard for him to, I mean, I think it needs
You
to
can't
be,
show the text messages without provoking the hearsay problem.
no, not to the jury, just to refresh.
Oh,
Because
that's
I think it's gotta be, he's not gonna know, it's just gonna be a weird picture.
understood.
Should we just go
Are
ahead
you going
and,
to publish the photo to the jury though?
no.
Oh, okay.
So, we could just go ahead and admit 340 now, because then the next question is gonna be, is this the same photo that is in this picture right here, and then we're done. Is this the same photo?
This is not a question for me. It's a question for Mr. Bloodworth.
No objection to admitting 340.
Okay.
I don't know that. Now there's the follow on. Is this the same photo? That is akin to publishing the photo that brings up the hearsay problem.
Okay, so they bicker about this for a good long time. We jump ahead a whole bunch because we will die here. And they're still bickering.
There is no foundation for the premise that Eric had a prior history of seeking fentanyl.
But that's not the way the question is worded. The question is worded, is someone contacting you, asking to give you information about it, and you refuse to interview them?
That's not the question you asked. Read the whole question.
In order to properly investigate,
No, go to number 2.
that is number 2.
My apologies.
And in order to properly investigate whether there was an accidental overdose, certainly any allegations, not facts, not nothing, just an allegation that Eric had a prior history of seeking fentanyl would be potentially relevant and important to look into, correct?
Let me ask it this way. What would your response be if Mr. Bloodworth got up and said, certainly, detective, you investigated whether Hayden Jeffs had done all the stuff that I've excluded in my ruling regarding Hayden Jeffs? Would you be like, no problem, you can say that?
So this is fun. So who is Hayden Jeffs? Hayden Jeffs was a handyman who worked for Kouri Richins. Hayden Jeffs is dead. Hayden Jeffs is he died in a motorcycle accident. There's no suggestion of foul play or anything. It's just an accident. But the allegation is that Hayden Jeffs said that Kouri Richins asked if he could get her fentanyl and if he could get her propofol. And so the judge is like, well, I've excluded that. I've excluded the Hayden Jeffs was asked for drugs because Hayden Jeffs is hearsay. Hayden Jeffs is, and the judge is like, look, you want to start opening doors about like the police investigation and what they did and didn't do. Well, then they get to bring in Hayden Jeffs, and yeah, she does not like this.
That's a fair question.
It would be
It's a fair question because it's exactly on point.
irreversible error for me to allow that question. There were 2 residual exception rulings in this case. Let's be fair about it.
Right? That's absolutely correct. So is there a way, if we scrub out the reference to fentanyl and we don't get into the specifics of exactly what was said, because I understand their concern about that and the court's concern, which is why we raised this in advance, which is why I'm trying to do the right thing here.
I appreciate it.
If we just said that an individual contacted them with information about an interaction with Eric involving drugs, illicit street drugs, and they chose not to investigate it at all, it does go to they've set forth this hypothesis that, well, we eliminated all other possibilities. And that's just not true. They didn't eliminate all other possibilities because they chose not to interview at least one person that clearly would have supported the first hypothesis, that he ingested it intentionally. So that's all I'm trying to get in. I am trying to get that in.
You may be trying to get a little bit more in.
Well, as much as I can possibly get in.
Fair enough.
But I do think it's fair game to say, look, you've got someone coming to your office saying he tried to buy drugs from me and I want to be interviewed. And they were like, no, thank you. I think I'm entitled to get that in. And I'm willing to do it in the most ethical, careful, reliable, non-inferential way possible.
Okay. Neat. Nobody believes you.
But I do believe that's fair game. And I'm open to suggestions. Whatever I need to do.
These 4 questions are not it, Mr. Bloodworth. You look like you're about to say something.
No, Your Honor, as I understand the status quo is the court's, I guess this court has sustained the state's objection to those questions.
I have. I think what Ms. Nestor is trying to ward off is another set of objectionable questions that are maybe more general, less specific, some version of probing the bounds of the state's investigation of the charges. Yep.
Your Honor, no, it's the same foundational objection, right? This is all to suggest that there is admissible evidence that Eric Richins sought fentanyl before. And at bottom, there is no admissible evidence that he sought fentanyl before. And I don't think that there is any good faith basis to suggest otherwise, or to suggest that any investigation into it was incomplete. Because the fact is, detectives, that Mr. Norris's narrative has been so thoroughly dispatched that there's no good faith basis to allude to an improper investigation, much less that there may be admissible evidence.
May I respond?
Yeah, hear me out for a second.
Sure.
Or let me make sure I understand the bounds of the argument here. You said there's no admissible evidence that Eric Richins.
All right, so we're going to jump ahead a fair bit more here. To the judge making this face. It's a good face for the judge. I think that this is an appropriate face. Unlike most of Kouri Richins' faces, but any closed captioning tonight, I'm sorry, it's got closed captioning is unavailable. So yeah. Your local egg dealer says, Runkle, please give your pup some extra love today in honor of my special girl, Stella, who crossed over the Rainbow Bridge this morning. I'm really sorry. Sorry to hear that. I will definitely give them some extra treats. So, yeah.
Let me just take 5 minutes.
Thank you, Your Honor.
Before I take a break, Mr. Bloodworth, anything further on this issue?
No, Your Honor.
Ms. Nestor, before we take a 5-minute break, any other issues before you invite the jury?
No, thank you, Your Honor.
Mr. Bloodworth?
No, sir.
Okay. For the proposition that what the defense is proposing to do is required, but it raises the prospect of also allowing the state to rebut the defense's charge of an incomplete or improper investigation by also putting in evidence, not for the truth, but for the effect it had upon law enforcement, of how they received and reacted to Hayden Jeffs' statements to his sister.
So I've got, would you be a judge if you had the opportunity? I don't think anyone will let me be a judge, but is it Runkle? Could you only wear your light blue, black, and white shirts? Maroon is it? No, I'm going to wear the shirts I have. So, yeah.
Pause for a second. I need you all to be very thoughtful about this. I can't.
The judge is like, please, 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 for the love of God, realize that if you do this shit, you own it. And you can't take it back. Oh, it was a yellow shirt joke. Okay, fair enough. Somebody in the chat yesterday was really upset about me having maroon shirts. So I was wondering if that was you. I don't own any yellow
once
shirts.
This information is out, and sitting here at the moment without the benefit of counsel's argument after reading this case, I think I'd have to let both sides of that story in to make sure that the state is not prosecuting with one hand tied behind its back. Mr. Bloodworth, I cut you off.
Sorry, Your Honor. We looked at this case while you had stepped out. I think in addition to Hayden Jeffs, it would also cause us to revisit the court's decision yesterday regarding Mr. Bon Savage's phone call with an inmate at Gunnison.
Ooh, I don't remember the detail of that one. Forgive me. Oh, I think I do. Yeah, a little bit. Now, let's talk about foundational requirements. I gave this a little bit of thought after rereading McCullough. There is some precision and some technicality into how these questions would need to be asked. For example, Ms. Nestor, you wouldn't just be able to put the substance of Mr. Norris's statement into question and ask whether Detective O'Driscoll ever followed up on it, because you would not have laid foundation that he ever knew about it in the first place. You need to lay foundation about whether or not he ever spoke to David Norris, yes or no. If no, did anybody ever relate to you that David Norris contacted the Summit County Sheriff's Office, yes or no? Yes. Okay, after that, what did you do? This information, this statements being made by David Norris to Summit County Sheriff's Office have to come in through a witness with knowledge of them. And I'm not sure Detective O'Driscoll's that guy. By the same token, to the extent the state would want to.
All right, so let's cut to the chase. What does the defense decide to do with this? They decide they are not calling this. They decide they're not pulling that trigger, which is a good move, because I think that would have been very dumb for them to do. So, all right, here we go. Jumping ahead. So ultimately, they decide, you know what, we're not going to blow up our own case.
Counselor present, Ms. Richins is present. Ms. Nestor, you've had an opportunity to confer with Ms. Richins. How does the defense want to proceed?
Thank you, Your Honor. Thank you for the break. We appreciated that. So we have reviewed the case. We clearly understand the court's ruling that if any of it comes in, all of it comes in. We get that. We also understand and appreciate that the court is going to require proper foundation, and we're not skipping any steps. We accept the state's representation in good faith that Officer O'Driscoll, he's out still. He is not the foundation witness, because he is not the individual who communicated with Mr. Norris. And we will, if we proceed with this line of questioning and we decide to introduce this evidence, we will do it through the proper foundational witnesses, which we accept as not him. So to avoid confusion now, since it's not him, we will wait and not ask the questions that he doesn't have, because it's like you said, there's no way to ask the question without introducing the substance. We couldn't figure out how to do that. So we're going to wait until we have a foundational witness, and then we will proceed that way if we can lay a foundation.
Okay.
And if we decide to go forward with that evidence.
I appreciate that. If you make that ultimate decision,
we'll give everyone a heads up.
I appreciate that. And one of the reasons I would need that is to make sure I give defense an opportunity to state on the record, or at least summarize on the record, their strategic balancing of the risks and benefits, so that there is a record of that going forward.
I appreciate that.
So what he's saying is, if you're going to make that choice, I want you to put on the record that it was your choice and that you made it intelligently asterisk, and that you are doing so on purpose for strategic reasons, so that you cannot possibly appeal this shit. He's like, I am not letting you just manufacture an appeal issue here. You have to basically give up the appeal issue before we can go forward. So, all right. So after that, they bring back Beardo. So yeah.
Court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury.
I believe he's got a name, but Beardo. It's Driscoll. Or O'Driscoll.
Exactly. Ms. Nestor, please proceed.
Good to see you.
Thank you, Your Honor. May it please the court. Good morning, Detective O'Driscoll.
Good morning, Ms. Nestor.
I believe when we stopped yesterday, we were talking about the GIFs or GIFs. And I want to start by having you review a document that's been agreed to by the parties. It is exhibit number 3-40. And at this point, Your Honor, we're asking to admit it per stipulation of the parties.
So the witness can see 3-40. And do we want to publish now, counsel?
Please.
Mr. Bloodworth?
No objections.
State's exhibit 3-40 is admitted.
All right. And this was talked about when, I believe it was Mr. Kostradimos, I think, it's all blurring together now, was on the stand. But this is the group of all the GIFs or the GIFs that were in kind of a group and included the ones that were accessed on the morning after the police left Ms. Richins' home, after Mr. Richins passed. Do you remember the testimony about that?
Yes.
Okay. Can we go to the page that shows the GIFs in question? Maybe blow that up at the top. Okay. So I think that's two of them. One of them is from, I guess, the movie Dumb and Dumber, and the other one is our president. And I think there was a third one, but it's, yeah, Mr. Spacey and in a TV program, right? And those are the three GIFs that were talked about. And if you blow up the time.
Now, this was something I said yesterday might be a big deal. I said we're going to talk about it when they're done because they only got partway through it. And people online have been fighting over this. So here we go.
That they were accessed. They all were accessed at 8:29:03 a.m. on March the 4th. That's the day that Mr. Richins was found deceased, correct?
Correct.
Right. And I know we've already heard the testimony that these are what we call orphaned GIFs. You can't really tell which text they came with and exactly when they were sent or who they were sent to or by. All we know is that they were somehow accessed at that point by her phone, correct?
That was the testimony, Mr. Cocherdemos, yes.
Okay. Can you pull up another one of the photos that is the picture from the house? That's it. All right. This is another picture that was accessed at that exact moment at 8:29. And can you blow the picture up a little bit? Do you recognize what that is, that photograph?
It's the legacy home.
It's the legacy home, right? And was there another photo that was accessed that same morning, also orphaned? Can you find that picture? It's right above it, I think. There we go. Can you blow that picture up a little bit? Thank you. All right. And is that also just a closer up view of the legacy mansion?
It appears.
I mean, maybe could also be a picture of a potato. It could be a picture taken with a potato. This could be like, I mean, we've got like 6 pixels here. It could be a whole lot of things, but all right.
That was very blurry on my screen.
It is. I think it is blurry. And then can you back out and show the time that one was accessed according to this same group of photos? That one appears to have been accessed at 10:42 a.m. the same morning.
That's what this document says, yes.
Okay. Now, if we could put just on the witness's screen, exhibit JO, I think it's 11, not for the publication yet, Your Honor.
Understood.
All right. And can you take just a moment and blow that up just a little bit so he can read it better? All right. Just take a second and scroll through that and tell me if that refreshes your recollection about any documents you reviewed about Eric's final communications before he passed.
Your Honor, objection. There's no foundation to get to whether or not his recollection requires refreshment.
Yeah, let's pause there. Would you lay a little bit of foundation before we get there?
Sure. And it requires us to go back to yesterday. So yesterday I had asked you right before we stopped if you had, as part of your investigation, reviewed the final communications of Eric right before he passed away, and you mentioned you had. Is that correct?
Yes.
All right. Based on that, if you could refresh, do you recall the communications you reviewed that day?
Not all of them. Some of them, yeah.
Can we then please blow up this document in front of him and see if this refreshes your recollection as to what you reviewed?
Mr. Bloodworth, the witness doesn't have it yet. Any objection to that question?
Your Honor, I think
I don't like the judge asking, like, inviting an objection. It should be, if Bloodworth's got an objection, he should come up with it on his own.
objection foundation. I think there requires additional foundation.
I think the question pending is, are these among the things he reviewed? Correct.
Maybe I misunderstood the pending.
Yeah.
That's the question.
So I think.
Can we back up a step? Maybe I'll catch up.
Sure. Ms. Nestor, ask your last question one more time, please.
Are these texts that are before you part of what you reviewed from Eric's final communications on his phone?
Go one step before that. He hasn't seen these yet. He doesn't currently have them in front of him.
Do you recall all of the communications you saw that day when you were reviewing Eric's final communications?
All the texts from his phone?
Yes.
On the day before he died?
Yes.
I don't remember all of them. I remember some of them.
So then would you please look at this document and see if it refreshes your recollection and as to whether these were included in his communications?
Any objection, Mr. Glover?
No, sir.
Okay. The witness can now see what you're referring to, Ms. Nestor.
Thank you, Your Honor. And can you go down just one more and maybe blow that up a little, that photo? Does this refresh your recollection, these communications of Eric's and Kouri's the day he died?
These are time-stamped March 3rd. That's not the day he died, but the day before he died.
Totally correct, because he died in, we think, the early morning hours of the 4th, right?
Yeah, he was pronounced deceased on the 4th.
Okay.
Yes,
So,
Your Honor, sorry, objection. Foundation is to the meaning of died, right? He was pronounced dead.
I think the witness and the questioning lawyer have a common understanding here. Overruled.
thank you, Your Honor. Okay.
Also, like, come on, you're objecting to, okay, all right. Like, that I thought was a really petty objection. And at this point in the trial, I just wish I had a spray bottle to like spray both sides just whenever they're doing dumb shit. Like spray Kouri for the shirt, spray her lawyers for like every time they open their mouth, spray, Bloodworth for that objection.
So were these included in what you reviewed in the communications between Eric and Kouri on the 3rd of March?
Yes.
All right. And this photograph, if you could blow that up.
Your Honor,
I like his tie, and I agree with this comment. That tie and shirt are a mismatch. Checkers and floor patterns just don't match. I like the tie. I don't like the shirt. Tie good, though.
objection. His recollection has been refreshed. I think the exhibit can now be set aside.
I'm not publishing it. I've just got one more question about the photo, and then I'm done.
I'll take you down and ask your question. If we need to refresh again, you can.
Okay, thank you.
Okay.
Wait, did you tell me I could ask the question?
Yeah, I took the photo down. Ask whatever you're about to
Yes,
say.
yes.
Okay.
Does the photo that you just refreshed your recollection with match the same photo that we just saw in 340? That was the corner of the Midway Mansion.
Your Honor, the photo is still up on my screen and the witness is
I apologize.
staring at it.
Sorry. Is it the same photo, sir?
This one that we just saw that was enlarged, you're asking if that's the same as the one in the text message?
Does it match the one that we just put on the screen for the jurors that came with all those other pictures that morning?
Yes.
Thank you. That's all I have. Done with that. I'm sorry, maybe I'm not. Can I have just one moment, Your Honor?
Of course.
The simple country lawyer shtick is getting on my nerves as well, but okay, she's making choices.
One more step. If we could go back to 340, which has been admitted, and pull up some additional GIFs that were accessed at that same time. If we could pull those up, please.
Sure. There you go.
Okay, so there's the picture on the bottom left-hand corner of the Midway Mansion house, right?
Yes.
What's this one on the right here? I'm just like, okay, so we got the Midway Mansion potato. And then we've got this dude with like one leg up in the air. And this person who appears to be angry at a wine bottle. I'm just trying to figure all of this out going, what are they sending each other?
And that one was accessed at 10:42 a.m. the morning of the 4th.
Yes.
And the one with the champagne is also that exact same time.
Yes.
And the one with the farmer is that exact same time.
Yes.
And we know for sure that the one on the bottom left was sent the day before. Because we just looked at that, right? And you refreshed your recollection.
Yeah, I don't know if the part of the extraction that we're looking at right now is saying that that's where that came from. I don't know if that's the same file path, but that photo is the same.
Perfect. Thank you. Okay, we can take that down now. All right. I also want to talk to you about, sorry, startle me. I also want to talk to you about the Google searches that were testified about here that were on Ms. Richins' phone or computer or both. Did you review those as part of your investigation?
Yes.
All right. And were you able to determine dates on all of those searches when they were made?
I don't believe so. Yeah, that would be a question for Mr. Cochradimos. I remember seeing the searches and the text of the searches, but I believe he testified that that there wasn't a timestamp associated with them, and that they differed from the action in the phone that showed that a link was actually clicked on from one of those searches.
Okay, perfect.
And I believe those had timestamps.
Okay, the links, but maybe not the searches.
Correct.
Thank you for that clarification. And you agree that as of April the 13th of 2022, approximately a month and a few days after Eric passed away, that Ms. Richins' house was searched and she was detained in a police vehicle, right?
Objection, Your Honor.
Foundation.
Yeah.
Sustained. Very little foundation.
Are you
They get into a dispute as to what detained means here. So that's a thing.
aware that there was a search conducted on her house on April 13th?
On Miss Richins' house?
Yes.
Yes.
And are you aware that while that search was being conducted, Ms. Richins was temporarily detained in a police vehicle for a period of time?
Objection, Your Honor, calls for a legal conclusion.
Overruled on that.
Go ahead.
I think the word detained is the problem there. I think there's been dispute over whether or not she was detained. But she was spoken to. She was asked to wait in law enforcement's vehicle until the lead detective could come speak to her about what was going on with the search.
Okay. So the searches on the website, fair to say that all of those searches are believed to have occurred after April 13th of 2022?
I don't know. Like I said, I don't know there were timestamps on the searches, so I can't be sure.
Did you ever interview any of Kouri's family or friends and ask them if they were responsible for any of those, or if they'd ever seen Kouri do it, or who did those searches?
No.
Okay. All right, I'd like to talk about the orange notebook for just a moment. We pulled up, do we have the, do you have that orange notebook exhibit? I can't remember the number of it. Court's indulgence for just a minute, I have the number. I've got it. I'll tell you. That,
Scott, 2-66R, please.
would he be so kind? I don't want to accidentally put something up that was redacted. Your Honor.
My apologies. We'll fix that. It's okay. One moment, please. Scott, if we do our normal dance, I'd appreciate it. (2-66R) publish.
Yes, please, Your Honor.
There you go.
All right, and can we, that's what we like to call the orange notebook, right? Because it's like in an orange kid's school notebook, right?
Correct.
Okay, and can you fast forward, Katie, to, until I tell you to stop? Keep going. Keep going. Keep going. Keep going. Okay, right there. And can you blow out the bottom third of the page? All right, so this orange notebook that was recovered from the house, you don't have any knowledge about the circumstances under which it was prepared, do you? Or why it was written?
I do not.
And you don't know when it was written?
No, I don't.
And this was seized the day Ms. Richins was arrested, which was May 8th, 2023, correct?
And I was like, okay, so they have this thing about the, the GIFs, and it completely fails to land. I thought they were going to make a big thing about these GIFs were clearly sent by Eric because they were on Eric's computer or on Eric's device, in which case they can say, well, it clearly wasn't sent by, or if Kouri sent it, it was sending it to Eric. So clearly not anything about the death, but it really goes nowhere. I don't think the jury,
I believe so, yeah.
So over a year after Eric's death, right?
Correct.
All right, and here on there's an entry that says on March the 22nd, can you highlight that please, Katie? Kouri starts counseling. Do you see that?
Mm-hmm.
You need to say yes.
Yes,
okay.
sorry.
Did you take any steps to verify if that actually was the date she started doing mental health counseling?
I didn't learn anything about her counseling from interviews that we conducted. We did get Kouri's medical records, and I don't remember if mental health counselor was part of those, but that's possible.
And I imagine as a, I forgot the word you used, as a serious crime investigator, homicide investigator, detective, death scene investigator, you've dealt with a lot of victims and family members who've been traumatized by a death and have required counseling. Is that fair?
My involvement with victims doesn't usually go that far to know whether they sought counseling or not. We refer them to the Victims Advocate Service, and they're much more equipped to help them with that.
Great. And have you ever heard of what's called trauma journaling?
No.
Do you know what that is?
No.
Okay.
No, maybe we're approaching.
I'll move on. I'm done with that. You
Are
don't know,
we
so-
approaching or moving on?
Why? We're moving on from the subject matter. No need to approach.
Got it.
We are moving on from the subject matter.
Very good.
All right. You also talked about the fact that you found it, I think you said suspicious, but I don't want to put that word in your mouth, but it was of significance to you that Carmen had placed a Mr. Richins obituary on her memory wall or her inspiration wall or whatever. Is that right?
I noticed it. Yeah. I mean,
Okay.
it was something that caught my eye.
Did you happen to notice if there were any other obituaries right around it or next to it?
No, I didn't particularly notice.
Can we pull up exhibit? Yes, thank you. The second one, 816R, I think. Oh, it's 15? Okay, 815R. And that's in, Your Honor, if we could publish it.
I can't see it yet, Katie. Oh, you don't have it. My apologies.
Oh, that
Scott,
one's got things
would
blurred.
you help us out? Thank you. Let's see. This is
Yeah.
8-15R. Let me just make sure this is the one you intended, Ms. Nestor.
That is the one.
And Judge, Katie does have this one. He wanted to switch back.
Okay.
Yeah, because I'm going to need her to blow it up. Can we
One.
switch it back to her, please? I'm so sorry.
No problem.
There was a recent version where they blurred a lot of children's faces out and stuff. Okay. Do you remember this picture we introduced of Mr. Richins' obituary on her memory wall?
Yes.
Can you please blow that up, Katie?
Now, I mean, there's some other things on her memory wall, like Ron John's Surf Shop, Yeti, Big Balls, says one sticker. I don't know what that's about, but apparently it was important enough to put up on the memory wall. So, yeah, I don't know.
To show what's right beside it or right under it. Do you see another in loving memory right below it?
Yeah, it looks like a program pamphlet from a funeral.
Okay. All right.
So basically the suggestion is she's got lots of, people who've passed on there. So clearly she didn't help kill all of them.
Also, the C&E hat, I believe, that was on that wall that you noticed. Did you do any investigation to determine if Carmen actually, if Carmen actually did any work for C&E?
Yeah, based on our conversations, she never worked for C&E as a company. She did work on the Richins house. She interacted with Eric, but she was never employed by C&E.
Okay. All right. I also want to show you a text. As part of your investigation of reviewing text between Eric and Kouri, Katie, if you could pull up exhibit 2 dash, I believe it's 9. 2-3. Thank you. That's it. Before you look at that, do you recall trying to investigating whether or not Kouri was aware prior to Eric's death that at least some, maybe not the house, but at least some of the assets that belonged to them or to Eric were shielded under some kind of a trust, if she was aware of that before he passed?
Yeah, that was part of our investigation.
Right. And did you review conversations she had with people about that and texts about that and things about that?
I didn't have any recorded conversations that she had. I guess it depends on the timing you're asking about.
Okay. I'd like to refresh your recollection and see if you look at these texts, if it reminds you if this is one of the things you looked at in trying to make that determination. Okay.
Okay.
Can you blow that up? It's exhibit 2-3D as in Delta.
I prefer when they say embiggen personally, but that's just me.
And just let him look at all of them, please, just slowly. Give him plenty of time to read. Can you go back up? I think we're missing that one. There you go, the next page. Does this refresh your recollection? Do you remember looking at this set of texts between Kouri and Eric?
No, I didn't have time to finish reading that.
Oh, sorry. Keep letting him read it. Recollection, do you remember reviewing this series of texts between Kouri and Eric relating to the trust?
I don't remember. In the context of those messages, I can't say that that's what they're talking about.
Okay, so this does not refresh your recollection.
No.
Okay, court's indulgence for just one moment, Your Honor. Without saying anything anyone told you, when you were conducting your investigation, did you become aware that Kouri knew of at least some portion of the some aspect of the trust being created before Eric passed?
Objection, Your Honor. More foundation, otherwise it's based on hearsay.
The foundation objection is sustained based upon the witness's prior answer. If you can start smaller, maybe build up to it. There may be some foundation here.
Did you interview people, look at documents, review texts to try to inform your investigation as to whether Kouri knew that Eric had created a trust for at least some portion of their assets prior to his death?
I reviewed information about the trust from several different sources. Everything that I reviewed suggested that she was not aware of how the trust worked or the consequences of the trust.
Totally fair. I think you're right about that. But was she aware that it existed?
Objection, Your Honor. Same foundation objection.
Overruled based upon his prior answer. You can answer, Detective.
I can't think of a specific instance, but I think there was some information that might have suggested that.
Okay, thank you. All right. Now I want to talk about Valentine's Day. You were here when Ms. Staking testified to the jury that in a conversation with a bunch of friends, there was some joking references made to Kouri wanting to poison Eric, and then Eric stating he had an allergic reaction and used an EpiPen. You heard that testimony, right?
Objection, Your Honor. Foundation. That's not what happened.
I think your recitation of Ms. Staking's testimony was correct until the last either sentence or clause.
Okay. Did you become aware that at least in some context there was a discussion on about the Valentine's Day incident relating to Eric taking an EpiPen, using an EpiPen?
Ms. Staking, from my memory, testified that there was a comment made by Eric in a joking manner that Kouri had tried to poison him. And then she said that Kouri's explanation was that it was an allergic reaction.
And that he used an EpiPen, right? Didn't she say that was the very last thing she said, I think?
I think so.
Okay. So did you do any investigation into whether or not Eric was treated regularly for allergies?
Yes.
And in fact, he had an allergy doctor. Is that correct?
Yes.
And he had an EpiPen device in the master bathroom that was recovered during the first search.
Probably. I know that there were some located in the refrigerator on one of the searches. EpiPens, that is.
Did you ever investigate whether Eric discussed this allergic reaction with his doctor, his allergy doctor?
I believe one of our investigators contacted the allergy doctor and conducted an interview. I don't remember what the results or content of that interview was.
Did you determine what Eric was allergic to? Was he allergic to avocados or wheat or peanut oil? Do you know?
From what I remember being told by the investigator that had that conversation, it was like seasonal allergies, trees, grasses, dander, things like that.
Okay. Were you ever able to confirm that Eric ever sought any medical treatment for what allegedly happened to him on February 14th?
Just that in his text message, he mentioned that he might go to the hospital. So I don't know for sure if he did, but he was feeling bad enough that he thought he might need to.
Were you ever able to confirm that he did?
No.
Okay. All right, I want to also talk to you about Miss Susan Kohler. Do you know who Susan Kohler is?
Yes.
Who is Susan Kohler?
She's an associate of Carmen Laubers.
So that was trying to undermine the poisoning notion. Now, if I was on the jury, I don't know. I'm kind of at this point a little on the fence on the murder charge, but I can tell you where I would not be on the fence at all. I would not be on the fence at all with respect to the attempted murder for the sandwich. The sandwich, I would just be like, that one is not on the table. There is no way you're gonna I'm just no. I can't see the sandwich being convictable here, right? So
She worked for Doreen Kouri cleaning houses with Carmen Lauber.
Okay. And in the course of your investigation, what did you determine, if anything, was the role that Susan Kohler played with respect to this case?
We determined that she sold, I think the number was 15 to 20 Roxy's or prescription narcotic pain pills to Carmen at the request of Miss Richins.
Okay. And was Miss Susan Kohler offered immunity like Crozier and Carmen Lauber were?
Objection, Your Honor.
Do you know?
What's the basis of the objection, Mr. Bloodworth? Or do you need to approach?
Relevancy.
Approach for 1 second. The relevance
Or
objection is sustained. Ms. Nestor, please proceed.
did you ever find any evidence or suggestion that anything Susan Kohler sold to Carmen Lauber contained fentanyl?
We found a bag of loose, I believe they were hydrocodone pills in the mudroom walkway cabinet in the house. They were tested. They did not contain fentanyl.
okay, that is a good, that is good. Excellent. Great. They've made some progress.
You also testified, I think, yesterday that shortly before Eric passed away, he went on a hunting trip to Mexico. We talked about that a little bit, right?
Yes.
Was there any effort made to try to track Eric Richins' phone movements while he was in Mexico during that time period?
I don't believe we were able to get any kind of GPS location data from Eric's phone. I think the location data came from call detail records, as was demonstrated by Mr. Cotradimos.
And you also reviewed the phone calls. Well, strike that. I'll strike that, Your Honor. Okay, I think I'm almost done. If I can just confer with counsel, I'm going to wrap it up.
Oh, thank God. The jury is sitting there like, please be done. Please be done. Please be done. The unicorn goal is to have an electric unicorn. So.
All right, we're almost done. So just to recap a couple of days of testimony that got interrupted a lot. This investigation has now extended for a period of over 4 years, right?
Correct.
Okay. And during that 4 years period of time, as recently as less than a month ago, you were still issuing search warrants. Is that right?
Yes.
And there were a total of at least 10 searches by law enforcement of Ms. Richins' home. Is that right?
There were 10 search warrants issued, yeah.
And
Or around 10.
you heard that there's also at least 5 multi-day searches by a private investigator. Is that right?
I don't remember if it was 5 days. He said a couple days.
And the agencies that were involved in this case were the Summit County Sheriff, right?
Correct.
The Medical Examiner's Office.
They're not a law enforcement agency.
They have investigator, right? She testified here.
Yeah.
Okay,
They're a civilian investigator.
fair. Also, there was a private investigator that was involved in this case and communicated with you and provided information.
No, he was involved in the civil case.
Did he provide you information?
He provided our office information. I never talked to him personally.
All right.
You see how much they're minimizing the private investigator here. Now, I believe the private investigator when he said he was doing good work. So he's like, yeah, that guy just existed, but we're really the ones who solved this. Me and my amazing beard. So yeah.
The DEA was involved in this case, at least briefly.
They never took any official action. Well, I should restate that. They assisted us with forensic tools,
Okay.
like call detail records and things like that.
Homeland Security agent, or I'm sorry, U.S. Postal Service agent was at one of the searches, right?
Yeah, I was aware of that.
Was that because they thought some drugs were sent through the mail? All right.
We've heard, I believe that we're over 45 witnesses now in this trial. Is that right?
I haven't been counting.
And in all of that, we have no murder weapon. Like, you haven't found anything that was connected to Eric's death. No fentanyl in the house, correct?
There was a boatload of fentanyl in his stomach that came out of the house with him.
Other than this, what's in his stomach? Did you find anything else that had fentanyl in it?
No.
Okay. You can't say how the fentanyl was administered, right?
Orally.
Besides orally.
That's all I know is that he took it orally.
We don't know exactly when it happened and what time of night or morning.
We know a time range.
Okay. You can't say the dosage that was ingested, right? 1 pill, 2 pill, 20 pills.
Illicit fentanyl does not come in dosages.
Okay. You can't say what was ingested on Valentine's Day at all, correct?
Fentanyl is definitely ingested. Oh, I'm sorry, on Valentine's Day.
Yes, on Valentine's Day.
No, we don't have any kind of medical examiner's report of his stomach contents from that day.
So, I mean, this one, I don't know, right? Because it could be anything. It could be that there was fentanyl. It could be that he had an allergic reaction. It could be that the very nice, restaurateur had some, like, a really old egg that they served him that, was bad. It could be that dude had it, like riding around in a warm truck all day and ate it later in the day and it had gone bad. It could be any number of things. And I just, I can't see how somebody could convict on the sandwich, to be honest. But, yeah.
And on insurance fraud, we have not heard any testimony about any representations that Kouri Richins made to her insurance company. Have we?
Objection, Your Honor.
If you put a word to it.
I mean, maybe Kouri Richins went into the restaurant and was just known for being an absolute shit tipper and like miserable person to be around. And they just like, wiped the sandwich under the fridge before they served it to her because they figured she'd eat the sandwich, right? We don't know. We don't know why he got sick.
Well, foundation also probably then hearsay.
Would you approach her one second?
Also, I don't like Bloodworth smirking. Like, stop the smirking.
And we've not heard any testimony in this case about statements or representations Kouri made to her insurance company, correct?
Not statements. We've heard evidence about it.
Okay. And with respect to the forgery count, we've not heard any testimony one way or the other whether Eric gave Kouri permission to sign his name on documents, have we?
I don't think that's required to meet the forgery statute.
He's wrong about that, but yeah.
Have we heard anything about that? Do you know one way or the other whether Eric allowed Kouri to sign his name on documents as a married couple?
No, but that's still signing someone else's name, even if they give you permission, purporting it to be somebody else's signature.
Okay, well, the judge is going to instruct the jury on what the law is about that. But what I'm asking you is, as the investigator, do you have any knowledge one way or the other if Eric ever said to her, hey, it's okay with me, sign my name, I don't have time to deal with it?
I don't know.
And in fact, what we have heard is that he did give her at least one power of attorney at some point years ago, right?
Objection. Well, not objection. Maybe approach.
Sure.
Thank you.
And you were here when Mr. Throckmorton, the handwriting expert, testified, and you heard him say that he could not say that Kouri Richins was who signed that document. Did you hear him say that?
I heard him say that it was probably
Not Eric.
probably not Eric.
But he could not say that it was signed by Kouri, correct?
Correct.
Okay. I think that's it. I appreciate your patience. Thank you, Detective. Thank you, Your Honor. We tender the witness.
Mr. Bloodworth, within the scope of cross, please.
Detective O'Driscoll, in this case, are you the lead investigator among many investigators?
Yeah, it's a large team. I've had a lot of help.
Does your job in part involve coordinating the activities of all the other sheriff's office investigators?
Yes.
And are you the lead investigator for the sheriff's office as opposed to the county attorney's office?
Correct. I have no authority over what the prosecutor's investigator does.
And does the county's, well, you may have just answered this, but does the county attorney's office have its own investigation capability and authority?
Yes.
Is it your job as lead investigator to be omniscient regarding every investigative detail in this case, to include details of the county attorney's investigation?
No, I can't know every single detail. It's, as defense knows, terabytes of information.
And in early 2023, was your personal investigative focus on determining the source of the fentanyl that caused Eric Richins' death?
Yes, because like I said at the beginning, I came into the investigations division as a narcotics officer. Before I became the lead investigator on this case, that was our focus, is investigating drug-related crimes.
In early 2023, did the sheriff's office have a digital forensics capability even remotely close to the capabilities of Mr. Cochodimos?
No, that's why we hired him.
And in early 2023, did the sheriff's office have any forensic accounting capability whatsoever?
In which year? Which date did you say?
Early 2023.
They had a little. I mean, how early? Not until March and April.
Well, let me ask you
January,
this.
0.
And any forensics accounting capability close to that of Brooke Carrington?
Oh, I'm sorry. Did you say forensic accounting?
Forensic accounting.
I'm sorry. I misheard. I thought you said digital forensics. No, the sheriff's office has no experts in forensic accounting.
And is part of the reason that they have no forensic
Part of the reason is that they don't deal with a whole lot of forensic accounting problems, so you hire somebody externally every time you need one.
accounting experts and minimal digital forensics experts, because you have a small office, right?
Yeah, it's relatively small.
The county attorney's office.
You got to be a really big office before you'd have cause to have an on-staff forensic accountant. I mean, there are places that might have an on-staff forensic accountant, like law enforcement places that might. Specifically, I think the IRS would probably have like an on-staff forensic accountant. But like, I don't think LAPD does. And you're going to struggle to find, larger police forces. I don't think NYPD does. So, yeah.
Has become involved in this case in early May of 2023 when me charged Kouri Richins.
Yes, we only met with the prosecutors about a week before to give them our probable cause information.
Subsequent to charging Ms. Richins, did the county attorney's office engage Mr. Cochodimos and Ms. Carrington?
Yes.
And is Mr. Cochodimos the investigator who analyzed the digital forensics, including cell tower mapping and cell phone data?
Yes.
And was it Ms. Carrington that investigated and analyzed the forensic accounting, including the closing on the Midway Mansion?
Yes.
And does the state provide the material from each of their investigations to the defense in discovery?
As far as I know, yes.
Do you recall in cross-examination when defense counsel picked a sentence from a May 2023 interview of Carmen Lauber, where it was either you or Detective Maynard told Carmen Lauber that she was something like the biggest piece of the puzzle?
Yes, I remember that.
What was the context of that comment?
She said something about can we just lay out all the information, all the pieces in front of us? Because we were trying to establish a timeline. And we told her, you're the biggest piece. You're the biggest part of the information that we don't know.
And
She had the information.
Sorry, I didn't mean to interrupt you. And did that context involve a piece of the drug purchase timeline rather than a piece of this whole giant case?
Correct. The timeline of her involvement, not necessarily the entire case.
And did that interview predate any information on the forensic accounting?
Yes.
And
We
did
didn't
it,
even get into that until well after.
and did it predate any of Mr. Cotodemos's investigation?
Yes.
And did it predate your understanding of Kouri Richins' relationship with Josh Grossman?
Yes.
Do you
So-
recall whether that
Basically, he's just trying to argue the investigation wasn't shit. It's just there's different people involved in different things and so forth. So, yeah.
that empty 2016 hydrocodone bottle that went with Eric Richins' body to the medical examiner's office was discarded by the medical examiner's office in August of 2022?
Back to hearsay.
Please lay some foundation. Sustained.
Do you recall what happened with the empty 2016 hydrocodone bottle?
Made my objection.
Detective, it's a yes or no. Start there.
Yes.
How do you know what happened with the 2016 empty hydrocodone bottle?
I was told by other investigators that they're
Objection.
Sustained on hearsay.
Did you or Detective Maynard give Carmen Lauber a ride to anywhere other than Wasatch County Drug Court or her attorney's office?
just here to this building
To this building?
to
or
meet
this
with prosecutors or talk with her attorney. They're here.
Can investigators force anyone to speak with them if that person does not want to speak with them?
No.
Can investigators seize someone's cell phone without a warrant based upon probable cause?
No, it has to be consent or a warrant.
At any time, have you believed that the walk the dog letter gave you probable cause to seek a warrant to seize Ronald Darden's cell phone?
No, it didn't contain enough information for me to have gotten a warrant.
Did your investigation determine that the EpiPens recovered from the Richins home were for one of the Richins children?
Yes.
The GIF image, the one with Kevin Spacey that says idiots, idiots everywhere. Is that from the TV show House of Cards?
From my understanding, yes.
Thank you.
Okay. Okay.
I'm sorry, is he finished? We have no further questions. Thank you.
May we release this witness?
Yes, Your Honor.
Mr. Bloodworth.
Yes, Your Honor.
Detective O'Driscoll, you are free to go. You are released from any subpoena.
Thank you.
Thank you, sir. Mr. Bloodworth.
Your Honor, the state has a stipulation to admit. I don't even think we have to publish it. It's up to the state that I think we marked it as 865.
Yeah, I don't get this one.
Admit that now.
Okay. Can I see it for a moment?
Your Honor, ma'am.
Please. Do you want me to give the Muji-Second stipulation of fact preamble and read this to the jury? Or do you want to just admit it?
Your Honor, I think if we can just admit it now during jury instructions, when the court would instruct on that, we can read this.
All right, we'll have a discussion about whether to convert this into a stipulation of fact instruction when the time comes.
Right.
Thank you, Your Honor.
Okay. State's Exhibit 8-65, titled Stipulation of Fact, is admitted by stipulation between the parties. Mr. Bloodworth,
Your Honor, state's in an interesting posture.
do you need a moment on the record outside the presence of the jury?
We do.
Okay. I think this would be an appropriate time to just set a schedule for the rest of the day. Are we going to be?
Spoiler alert, the schedule for the rest of the day is basically to pack up and go home. But
Your Honor, the state's waiting on the defense's decision regarding the Norris matter, because if they want to proceed in one fashion, the state will call some additional witnesses in its case in chief. If they want to proceed in another fashion, then the state will rest.
This is what I was trying to tease out, and I apologize for not being more specific. Given that
So the prosecutor is like, look, if the defense is going to do the stupid thing that lets us get in all of this additional evidence to go after them, then we want to get that evidence in, and we want to hit them with a brick. Whereas if not, then we don't need those witnesses. We can let the brick have a day off. So that's what he's asking.
he did not open the door to this issue through any of the state's witnesses in the state's case of chief so far. I understand the possible order of events from this point forward to be they'll make a decision about whether in the defense case to open the door to it. If they do, the state would be able to respond by, among other things, publishing evidence of Mr. Jeffs' statements and, forgive me, the other gentleman,
Bonsavage.
Mr. Bonsavage's statements as part of the state's response to or rebuttal of the defense's theory of a failure or to investigate or incomplete investigation. But they haven't opened the door yet, so I don't think there's any need or ability for the state to get into it in its case in chief.
Okay, Your Honor, then the state rests.
Okay. With the state having rested, Ms. Nestor, does the defense have a motion?
We do, Your Honor. Mr. Ramos is going to take care of that.
So the reason why they're asking is, does the defense have a motion, is because this is a motion for a directed verdict, right? This is a motion to basically say, Your Honor, there is, there's no evidence here, so things should be thrown out. So that's the, what is it? That's kind of the thing there, but we already know where this is going to be, right? These directed verdict motions, you have to make them, but you already know that it's not going to happen. The standard is so very low. Is there some evidence that could possibly be believed on the, subject, awarding like every possible deference to the prosecution side to say that, that this is met, right? So basically some evidence on every element. The only time that this is successful is where the prosecution has failed to call any evidence as to who your client is or something like that. In Canada, you're not actually required. In the US, the tradition is you always make the argument. In Canada, not so much. In Canada, you're expected to only make the argument if you actually think you've got the argument. But in the US, they always make it. So who do they give this to? They give it to Ramos because he's the junior guy. So they're like, go make the argument where you're going to get shot down and lose. But he actually does a pretty good job. I actually think Ramos does a decent job with the argument, just keeping in mind that you do the decent job, but he's lost before he gets up, right? Before he stands up, everybody in the room knows he's not going to win on this. So be aware of that.
Your Honor, under both Rule 17-0 as well as 77-17-13, discharge for insufficient evidence, the defense presents the following and moves for a directed verdict. At the conclusion, this is just for the record, Judge, as Your Honor knows, at the conclusion of the evidence by the prosecution, which has just been done, the court may issue an order dismissing any information or indictment or an account thereof upon the ground that the evidence is not legally sufficient.
This is because he's a junior. A more senior lawyer would not include this part because you don't generally give the judge the test for things where the judge already knows the test because it's super obvious, right? So, he's reading the standard to the judge, but the judge is like, we know this.
Sufficient to establish the offense or offenses charged therein or any lesser included offense. Judge, based on the evidence that has been presented over the past 10 days or so, including all inferences, of course, that can be reasonably drawn from the evidence, it is the position of the defense that some evidence exists from which a reasonable jury could find that some, however, not all of the elements of the crimes that have been proven beyond a reasonable doubt. In terms of the sufficiency of the evidence, Judge, I'll start backwards, starting with count 5. With regards to the forgery, even looking at all the inferences in favor of the state, we do not believe that the state has proven a specific intent to defraud as it relates to the forgery. There's no proof that the signature was done without Eric's authority. And even assuming that the defendant, Ms. Richins, signed on behalf of Eric with or without permission, that itself does not conclusively presume that because she signed the name of Eric, that a forgery has occurred. The act, in other words, of signing another's name without permission doesn't constitute forgery, again, unless it was done with the intent to defraud, which we don't believe it has been met here. In terms of count 4, and forgive me, Judge, the way I'm approaching this is based primarily on the information, the criminal information, as the facts were laid out there. It was a bit difficult to follow through the testimony as to exactly what the state's position is. According to the criminal information, the basis for the true stage, count 4, insurance fraud is that Ms. Richins, or rather, True Stage left the voicemail with Ms. Richins requesting a copy of the prescription, any prescription Mr. Richins had for fentanyl. Then later that same day, Ms. Richins informed True Stage that fentanyl was not prescribed and that she had no idea how Eric obtained the fentanyl.
I think it's that last clause of that sentence that this is the state's prima facie showing. Do you see it differently?
And taking that as their basis, what the evidence has shown thus far has been that Ms. Richins sought and procured oxy from Ms. Lauber, that while Ms. Lauber indicated that it was fentanyl, her source, Mr. Crozier, provided fentanyl, that Mr. Crozier did not provide fentanyl. Rather, he provided prescription-grade oxys. From that moment, from the supplier, Mr. Crozier, to Ms. Lauber, the evidence is that what was provided was oxy.
May I ask you a direct question about that?
Sure.
Why couldn't a jury, properly instructed on the law and consistent with the court's duty when considering a motion for directed verdict, drawing all inferences in the state's favor, view the evidence as showing that Robert Crozier sold to Carmen Lauber 15 to 30 bluish pills marked M30. Carmen Lauber provided them to Kouri Richins, and then, based upon the testimony of Eric Haskell, that during that time frame, bluish pills marked M30 likely contained fentanyl?
Two responses. One, the testimony from Mr. Crozier as to the quantity and the amount per pill does not jive at all with the Haskell testimony as to how much fentanyl grade, or I guess street level.
Yeah, the problem with this does not jive is that ultimately that's a jury question, not a judge question. So yeah.
Non-prescription pills were going for. What was indicated in the evidence was the amount that was paid was consistent with prescription grade oxys. So that's how I would answer your Honor's question.
Okay.
Count 3,
at the end of the day, if it's debatable, if it's interpretable one way or another, it gets interpreted in favor of the prosecution for the purpose of these applications. I also just want to say Ramos has been doing a much better job at he changed his style dramatically from the first day, and he's been doing way better since then, like massively better since then.
I understand it is that Ms. Richins, again, according to the criminal information, had indicated a phone number with an incorrect digit. The signature on the application that purported to be Mr. Richins is a forgery. We talked about count 5. And then in the context, and I think it was also the P.O. box. I imagine they were trying to establish that Mr. Richins didn't have access to that or something to that effect. I don't believe any evidence has been presented to that degree, or that
PO box circumstantial evidence that Eric didn't know about it.
not necessarily.
If I view the inferences in the light most favorable to the state.
And even with that, Judge, I mean, there was no evidence presented at all that from the Postal Service or anybody saying that Mr. Richins had no idea that that PO box existed. There was a statement and a question made by, I believe, the state, but no evidence was presented to show that that was actually the case. That's how I would answer Your Honor's question. Also, an interesting point. Term life insurance.
When lawyers say this is an interesting point, they rarely mean it, but
At the moment that she allegedly signed on behalf of Eric and was submitted and was paid from her account, I am not certain that Your Honor could find that that term life insurance actually had value. What I mean,
now I do actually think this is an interesting argument, but I don't think it's going to go anywhere. So he's saying the term life insurance is valueless because it's just an inchoate document at this point. So, yeah.
by that is that there is case law, of course, in the civil process or context, that in the context of term life insurance, Utah courts have specifically addressed whether such policies have value as property. And the Court of Appeals in Beckham v. Beckham, I didn't write down the citation, I'll provide that, Your Honor, held that term life insurance policies generally have no cash value and therefore no property value. This is, of course, in the context of marital assets. So I bring that up. I think that's an interesting point. Obviously, it was marked for $100,000, but the actual value of that.
So the argument here is that it can't be fraud if she's messing around with the term life insurance because it's a worthless item. And the thing is that's for like property division for marital assets, they concede. So basically what that means is that if you've got a life insurance policy for $100,000, it's not that $100,000 gets divided up in the marriage at divorce. I don't think it's going to fly, but I think it's an interesting argument. I think it's worth, yeah. Jace Makes, shoot me an email. I'd be happy to discuss. So, yeah.
I don't know, it raises an interesting issue.
Doesn't the statute talking about the elements of that particular crime for count 3 talk about property, money, or things obtained or sought to be obtained?
Correct. And that was going to be my last point, is at that moment, what the state needed to provide or prove, put forth evidence, is that at the moment that Ms. Richins allegedly signed on behalf of Mr. Richins for $100,000 term life insurance, that at that moment she knew that she was going to attempt to take her husband's life. And I don't believe they've met that, Judge. That's how I would answer that.
Okay.
With regards to count 2 and 1, most of these arguments overlap, but I will attempt to keep them separate, Judge. As I understand it, in order for them to have met the elements, in order for Ms. Richins to be found guilty of an attempt, she must engage in conduct constituting a substantial step towards the commission of the offense. Here, evidence has been presented that she did seek to obtain oxy. We've had that discussion. Obtaining that oxy, just obtaining the oxy itself, is mere preparation. There is case law, as I'm sure Your Honor is aware, in State v. Johnson, 821 P2D 1150, that indicates that that is not enough. Coupled with the information that we just discussed as to whether it was oxy, whether it was fentanyl, I believe that's even Ms. Richins' case currently is even in a better posture than Ms. Johnson. So with that, if we look at it in the context of the Valentine's Day, there is no evidence at this point that what was obtained was fentanyl, one. Even if it was oxy and she sought to obtain that, beyond that, there's nothing else, no other evidence that indicates that Ms. Richins took those pills, the greenish blue ones, I think at that time 15 milligrams is what Mr. Crozier said, and did anything else with it. I think the evidence as to Mr. Richins ingesting a sandwich is clear. In terms of Ms. Richins picking it up, absolutely. That his reaction was a result of that and not anything else, I believe that the evidence is scant.
I'd agree with that, although the judge is kind of rolling his eyes.
Your Honor has a question.
No, I'm following.
I will say that even in the Johnson case, the evidence was clear that the defendant in that case had actually obtained a specific type of drug, methamphetamine. So even in that case, they knew exactly what was obtained. Here, it's unclear what was obtained. I will add this before I forget. It relates to all of this in your prior question. In terms of the pills, Ms. Lauber testified the amount of pills that was significantly different from what Mr. Crozier had indicated, as well as the packaging. I believe that's important in the court's consideration in terms of what type of pills ultimately were given from Mr. Crozier to Ms. Lauber. This same argument, not to rehash it, applies to count one. And it leaves us with the administering of the drug. Zero evidence has been presented besides that fentanyl was in his system, in his gastric, and it was possibly orally ingested. There has been no evidence in terms of the administering of whatever it was at all.
Now, the thing is that the jury is entitled to draw some inferences here. They don't need direct evidence that, like, somebody saw Kouri Richins put it in the mule cup, or even testing of the mule cup. They are, they can make the inference that it was in the mule cup, right? They can make the inference that that was the method. So, yeah.
Judge, for those reasons, the defense requests that Your Honor exercise your duty under both the Rule 17 as well as the code, and we move for directed verdict on those counts, Judge, for those reasons, unless Your Honor has any questions.
I do not. You'll get the last word.
Thank you.
Your Honor, can I perhaps begin by asking the court if the court has any particular element that they would like the state to speak on?
No, I understand the standard. I believe I understand the state's theory on each of the counts.
He's like, is there anything I might lose on? That's what he's asking. Your Honor, are you entertaining this? Is there something I actually need to address? Could I lose on any of this? And the judge is like, I don't think so.
Especially 1, 2, 3, and 4. Speak to count 5 if you want to. Specifically, Mr. Rambis's argument regarding lack of believable evidence regarding intent to defraud.
Your Honor, it ties into count 3, right? It's the same insurance. This is the $100,000 true stage policy. And the scheme charge, the scheme fraud in count 3 is that Kouri Richins, at the time she took out that $100,000. Well, this is interesting. The timing doesn't matter for count 3, but the timing does matter for count 5. That as it relates to count 5, at the time she forged Eric Richins' signature, she intended to defraud. I think the evidence that supports her intent is the fact that nothing on the face of the application indicates that Eric would know of this application, right? The mailing address, the email address, the phone number, everything, the payment, everything comes back to Kouri Richins. And she signed this, I think it was late January 2023, at a time when she had...
January 29, 2022, correct?
I'm sorry, 2022. It was the end of January 2022, at a time when she had already begun asking Hayden Jeffs and Carmen Lawbar for drugs of some sort at a time when she had already expressed her interest in starting a fresh life with Josh Grossman, and at a time when, she had told Becky Lloyd that she would be better off if Eric was dead, and at a time when she had told Josh Grossman if he would just go away. So there is sufficient evidence in the light most favorable to the state that a reasonable jury could find that on January the 29th, when she forged Eric Richins' name, she had intended the entire fraud scheme that's charged in count 3.
Understood. Anything further?
No, Your Honor.
Okay.
Thank you.
Mr. Ramos, anything further, sir?
Just briefly, and this is, of course, Mr. Bloodworth wants to respond to this. I did neglect in my argument initially as to count 2, the testimony regarding the joking nature conversation that Ms. Stakings had that she testified to with both Ms. Richins and Mr. Eric Richins. Of course, Your Honor, heard that, so I would just add that for the record.
Understood. Thank you. Mr. Bloodworth, anything further?
No, Your Honor.
All right, folks. I appreciate the argument. This is an important motion. Let me just take 5 minutes to collect my thoughts, and I'll give you a ruling. We'll be.
I'm just going to say it's unusual that the judge takes 5 minutes to collect thoughts on this, because usually what they do is just say, okay, it's denied. There is enough evidence on that. I see. Can you please explain beyond a reasonable doubt and reasonable doubt when you have a moment? That might change my mind some. So you don't need to prove things to an absolute certainty, like an absolute mathematical certainty, because in most cases you cannot. It's not possible to do that. But a reasonable doubt is greater than a probability. It's greater than a likelihood. Beyond a reasonable doubt is greater than a probability. It's greater than a likelihood. It's greater than even things like pretty sure. Beyond a reasonable doubt is the kind of standard you'd apply to really serious choices you'd make in your life, right? So an example that they give is things like, well, if you've got, if you were pulling the plug on a family member, you were removing life support from that family member, you would want to know beyond a reasonable doubt that the person was not going to recover, right? And so that's kind of like one way people have described it. But beyond a reasonable doubt, again, it's not a mathematical certainty. It's to a very strong degree of confidence, right? So that's something you got to be aware of there. You got to be, you got to sort of, and they'll describe it during the closings, right? Because if the defense does not hammer on beyond a reasonable doubt, then they are crazy. They are dumb. Nope, that one was used in Faust, was where they used that. Still hoping for a Potter's eyebrow sighting. We can do Potter eyebrows. So another example of like beyond a reasonable doubt might be, you conclude that it's raining outside, and, you might conclude that because you see somebody come in from outside. You don't actually see outside, but you see somebody's just come in from outside. They are soaking wet. They're carrying an umbrella. They close the umbrella off. The umbrella's wet. They say, man, it's really pouring rain outside. And so from that, you might conclude that it's raining outside, but you don't have that to a certainty. You just have very strong evidence, right? You have the water, you have their statement that it's raining outside. You've got no reason to doubt this person. You know that on the weather report, it said it was probably, like a 90% chance of rain that day. You know all of these things, but you didn't actually see the rain, right? You didn't actually go outside. So, but you still wouldn't have any question in your mind when you decided that it was rain just because just because maybe I didn't see it, right? So that's kind of an example. Now, what that looks like in a specific case will vary depending on the cases, but yeah.
Recess until 5 of noon. Thank you.
All right.
All right, so he comes back and he's got a decision that he's gotten written out carefully to make sure that there's not going to be an appellate issue here.
It has long been established that the elements needed to make out a cause of action may be proven by direct and by circumstantial evidence. And if there is any evidence, however slight or circumstantial, which tends to show guilt of the crime charged or any of its degrees, it is the trial court's duty to submit the case to the jury. When evaluating a motion for directed verdict, the court is not free to weigh the evidence and thus invade the province of the jury, whose prerogative it is to judge the facts. Rather, the court's role is to determine whether the state has produced believable evidence on each element of the crimes from which a jury, acting reasonably, could convict the defendant. Not will, not would, but could. Moreover, the evidence must be viewed in the light most favorable to the state. Applying these legal principles as announced by the Utah Supreme Court in State versus Montoya, 2004 UT 5. The court finds that the state has established a prima facie case against defendant Kouri Richins by producing believable evidence of each element of each crime charged in the operative information. Defendant's motion for directed verdict is respectfully denied. Ms. Nestor.
Now, I'm sure that Nestor and Lewis and Ramos all told her that there was no hope that this would be granted, but that they have to make it anyway.
You asked for time to speak with your client to make some strategic decisions. Is between now and 1 p.m. sufficient time?
Yes, Your Honor.
Okay. Mr. Bloodworth, anything further before we recess until 1 o'clock?
Nothing further, Your Honor.
Ms. Nestor.
No, sir.
All right. We'll be in recess until 1 p.m. Just confirming that to the extent.
And good news, we don't have to wait until 1 p.m. because this happened today.
President 231-500-139. State's Counsel and Defense Counsel are present. Ms. Richins is present.
So I see this question. I don't understand the light most favorable to the state and the significance of that statement. Isn't this meaningless then? So, for example, let's imagine that, there's a, my client is accused of walking around with a gun visibly tucked into his pants, and he's not allowed to do that, right? So that is the, that's the evidence. They say we found this, we saw a gun, whatever else, but nobody test fires the gun, right? Nobody actually checks the gun or whatever else. And one of the witnesses says, I didn't know if it was a gun or an airsoft gun. It might be an airsoft gun. Okay. So now we've got contradictory evidence. Is it a gun? Is it an airsoft gun? Right? What is this thing? Now, on a motion for a directed verdict, it's a gun. And the reason why it's a gun on a motion for a directed verdict is because you have to take that evidence that is like muddled and mixed as to whether it's a gun or an airsoft gun, and that has to go on to the benefit of the state, right? So you take it in the light most favorable to the state, and it's a gun. But if the only evidence was that it was a fake gun, like the only evidence was that it was an airsoft gun, then taking the evidence as it is in the light most favorable to the state, it's still an airsoft gun because literally nobody testified that it could be a real gun. So you see sort of the difference there. Usually when the state loses on this kind of thing, it's because the lawyer fucked up. So as an example of one of these fuck ups, there was a case where they didn't mention at all in the trial where the offense happened. And so they went through the entire trial, and the lawyer, like the the prosecutor, this was a Crown prosecutor because this was in Canada. It was not my file. The Crown prosecutor failed to testify to anything or failed to have any of their witnesses testify to like where the events happened. And so at the end of the trial, the defense lawyer, who was not me, got up and said, I need a directed verdict because we don't know the jurisdiction. And the prosecutor was like, I think we did call evidence of jurisdiction. And so they actually had to go through and listen to the audio recordings. And they listened to the audio recordings all the way through. And nope, there was no, there was no jurisdiction. So at the end of it, it was like, nope. But you can get stuff like that. Didn't Rittenhouse have a directed verdict with respect to the gun charge because of the length of the gun? It's been a while since we were covering Rittenhouse, but I think so. I know there was one directed verdict because of the law didn't actually ban him from having firearms. Can they retry? No, they can't. You only bring the directed verdict after they've closed their case, and that's it. They're done. So, all right.
Mr. Bloodworth, would you like me just to tell the jury when they come back in that the state has rested?
Yes, so that's fine.
Okay, will do. Ms. Lewis, Ms. Nestor, what's the plan?
Ready to go.
Who's defense counsel's first witness?
Oh. Wait, just a minute.
Yeah.
We have.
So this I thought was really interesting because they say ready to go. They're asked who their first witness is, and then watch this.
A couple of options.
Understood.
They have a little conferral. They're chatting about this.
You don't want
to. She's like, "What are you doing?" Because she just said something into the mic. I mean, the thing is that they just had a fucking hour, right? The judge just said, okay, you have an hour to decide what your strategy, like what your plan is. And now here they're fiddling it out. Like, why?
Your Honor, actually, at this time, the defense intends to arrest.
We should probably do that in front of the jury, yes.
Right?
Okay.
I agree.
I just want to make sure you've consulted with your client about this.
Absolutely.
Is now an appropriate time to get a waiver of Ms. Richins' right to testify on the record.
Yes.
So the reason why they want to do this is because, or the reason why the judge wants to do this is because Kouri Richins has the right to testify if she wants. And that is a decision that Kouri Richins gets to make, even if her lawyers disagree. In Canada, can the Crown appeal a directed verdict? Yes, but only really on the grounds that they were wrong on the directed verdict or, got the law wrong. So, if Kouri Richins says, I want to testify, and the lawyers don't think she should, Kouri Richins gets to testify. Similarly, if Kouri Richins says, I don't want to testify, and her lawyers are like, you need to testify, then she doesn't testify. But the judge wants to make sure that this is appeal proofed, and the way he's appeal proofing this is that he's going to confirm that she's not going to testify. So that's what they're going to do right now.
Okay. You've consulted with Ms. Richins about her, or advised Ms. Richins about her right to testify, correct?
At length.
Okay. Ms. Richins, may I ask you 2 direct questions?
Yes.
Do you understand that you have the right to testify at trial?
Yes, I do.
Are you following your attorney's advice and waiving your right to testify at trial?
Yes, I am.
I accept your waiver. I find it's knowing and voluntary.
Yeah,
okay, thank you. Anything further on?
Okay, so I was a little surprised by the whole resting scenario here because all the way through this trial, the defense has been saying, we're going to be calling a drug expert. We're going to be we're going to be recalling some of these prosecution witnesses. We're going to be calling this person and that person, and now they're resting. And there's basically a couple of reasons why they might do this. Reason number one, all of their witnesses might suck. So it might be that they're resting because they just don't think that they're going to move the needle, because they're like, our witnesses suck. We don't want to, we don't want to do that. I don't think it was a good idea for Kouri Richins to testify, because Kouri Richins, it'd be awful, right? So reason number two is the defense may think they're winning. The defense may say, look, we've got this, or at least we've got this as much as we're going to get this. And so we don't think that we can make our case any better by bringing on any of these witnesses. We'll just let it go here. That's, their thing, right? They can make that call. And the third reason why they might be doing this is they might just be so terrified of the possibility of opening doors that they don't want to open, that they're just like, we're not going to call any evidence because that way we can't accidentally open a door that might cause us problems. But I don't know. I wanted to hear from some of those, like the drug expert, from those other things. I think the jury might punish her for not, bringing those witnesses in. They're not supposed to, but they might. It's certainly possible. I just look at this and I'm not sure it's a good call, but I can't say for certain whether it's a good call or not, because I don't know what they have in their back pocket, right? If the witnesses they've got lined up are all shit, then this might be the best call. But if they had a witness who was lined up, who was like, let's pick a ridiculous example. Let's pick something that is absolutely ridiculous as an example for like a great defense witness. Defense calls Bob, and Bob is going to testify that he climbed through the window and forcibly injected fentanyl into Eric Richins' stomach, and that's how he died. Bob is like, I totally killed him just because I felt like doing it, and here's how I did it, and here's all the evidence, like here's the syringe I used, here's a videotape of me doing it. Like, if they had that witness, then they would be crazy not to call Bob. But I don't think Bob exists, right? But things like a drug expert might have been helpful. So what I suspect we're going to see is we're going to see a prosecution close that is going to focus, they're going to go through everything, but they're going to focus on like the walk the dog letter. They're going to reference the luxury, prisons for the rich. They're going to like all of these things, right? The defense lawyer is going to, like the defense counsel, is going to very heavily focus on reasonable doubt if they're smart. And I think they're smart enough to do this, to focus on reasonable doubt, right? Where they're going to say, proof beyond a reasonable doubt is beyond maybe. It's beyond probably. It's beyond I think so. It's beyond, it gets to, there are no other alternatives. It gets to, this is the only plausible thing that could have happened. It gets to, there are no big unanswered questions. And then you can say, here, there are a lot of big unanswered questions. We don't know how the fentanyl got into Eric Richins. They say, well, she must have fed it to him. But we don't know that. We don't know if he took the pills on his own. We don't know if it was in a gummy. We don't know if it was like a magical elf. I have an alibi. We don't know, all of these things, right? And so that's going to be the defense position, right? They're going to say they've got these GIFs because they can never decide which one they want to say. But those were sent before. She just opened them in the morning. That's all we know. These kinds of things. So we just don't know, right? What is it? Why do criminal clients have more rights than civil clients regarding participating in their case? The reason is because a criminal client is facing the full weight of the state as opposed to another person, and also because criminal clients are at risk of jail. So criminal clients, they could go to jail forever, whereas civil clients, you're just looking at money. That's also why civil cases are on a balance of probability standards as opposed to other cases that are on like criminal cases, which are on the beyond a reasonable doubt. Part of the reason for you have the right not to testify and not to speak is because of what the police used to do, which was, hey, Bob, we suspect you committed a murder, and we're going to punch you until you tell us what happened. Because when you didn't have a right to not talk, they could just hit you until you said things, right? So we don't want to live in a world where the police officer is allowed to punch you in the gut until you say what they want to hear. So we have a right not to testify. That's kind of important. So, yeah. Runkle, if she's found not guilty, do you think she'll be still held in jail pending her financial criminal trial? I don't know, because I think that the bail on the financial charges is a lot easier to justify than on the murder stuff. So, yeah, I expect we're going to see the defense focusing very, very heavily on this is what reasonable doubt is. You cannot convict because they have not proved it. That's it. I think this case would be a fairly easy win for the defense if the prosecution didn't have the walk the dog letter, the prosecution didn't have the Google searches. Those things are big problems for her because, luxury prisons for the rich. Can you wipe a phone remotely? Poisoning, all of these things are terrible searches. They're just awful. So we're going to cover closings when they happen, but let's dive right back into the judge explaining things.
Record, Ms. Lewis. Mr. Bloodworth.
Ramos. Ramos, Nestor, Lewis, in that order of preference.
How would you propose we proceed from here for the rest of today?
So let me backtrack a little bit on your earlier question. I think I should then rest in front of the jury.
Understood.
The defense can then rest in front of the jury. I think then for the rest of today, and I propose tomorrow, the court recess, and that we begin, the parties can work on jury instructions perhaps today or tomorrow, but then we instruct and close on Monday.
My face is not telegraphing any opinion one way or the other. I'm just waiting for a response.
He's like, stop trying to get hints. I'm just waiting for you to talk. This works for me because tomorrow I am going for a birthday dinner with Mrs. Runkle. So I might be able to do something late, but it would be late. I don't know if Rob is streaming. I suspect not, but
I don't think we have a problem with that. I thought we were thinking it might make sense to get the jury instruction conference out of the way, and then
I agree with you. May we do it tomorrow? Give the counsel both sides a chance to talk to each other about any additional instructions you think might be necessary, narrow any differences or discuss any differences you have regarding any of those, and we can have that conference tomorrow.
yeah, yes, that's right.
Okay. So we'll talk about scheduling about that. Just want to make sure we're all comfortable with the jury being out in the wild between now and Monday morning. Yes?
Yes.
Yes, sir.
Okay. Okay. All right. Are we ready for the jury? Mr. Bloodworth?
Yes, sir.
Ms. Lewis?
Yes, sir.
Okay.
All right, here they come in. We can skip ahead.
Your Honor, the state rests its case.
Very good. Ms. Lewis?
Your Honor, after consulting with our client, the defense rests.
Understood. Thank you. Ladies and gentlemen, there is some legal work that I need to do with counsel in this case to get from here to the next stage. Rather than use your time inefficiently with you in the courtroom, we're going to do the following. We're going to recess for today. You will be on your own in the wild between now and 8:30 a.m. on Monday morning.
Rob streams, but he's had some real life stuff come up, which is getting in the way. So I don't want to get into what his real life stuff is. I know what it is, but I don't want to share his business. But he's dealing with some shit. So he's not able to stream, or he hasn't been able to stream for the last little while. So yeah, just be aware of that. Rob is coming back. So
I cannot emphasize this enough. Between now and 8:30 a.m. on Monday morning, please do not say anything about this case to anyone. I would understand if you had to tell somebody that you have to be back here at 8:30 a.m. on Monday morning. Other than that circumstance, please do not discuss this case with anyone. Do not allow anyone to attempt to talk to you about it. It will take.
do not watch Runkle. Do not watch Lawyer You Know. Do not watch Emily. Do not watch Brother Counsel. Do not watch any of the things. So, yeah.
Affirmative effort and diligence. I need you to use that same affirmative effort and diligence to make sure you avoid watching, listening, or reading anything about this case from any source whatsoever. And please do not do any search, research, query, anything of any kind between now and 8:30 a.m. on Monday morning. Please travel safe.
So what time tomorrow am I streaming? Tomorrow I am I'm doing dinner with Mrs. Runkle. I can't see anything happening before 7:30 or 8 my time. So yeah, if I stream, it'll be late.
Enjoy your weekend. I'll see you at 8:30 a.m. on Monday.
I'll try to at least have a video that you can have online to watch. So
Rise to the jury. All right, folks, have a seat. May I propose the following? That counsel have an email exchange or a phone call, say 4 p.m.-ish today, about the state of the jury instructions and whether you think there need to be any additions or amendments. And then, to the extent there are, please send me an email or file something in the docket and let me know that you did. And then what time would you like to get together to talk about the instructions one by one tomorrow?
9:30,
Do you want to do it a little later just so I have time to look at whatever happens?
You suggest?
late as possible.
Want to do it at 1?
Yes, sure.
Mr. Bloodworth?
Sure, sir.
All right.
okay, so let me tell you, I am going to watch the jury instructions stuff. I am then only going to decide if I want to cover the jury instruction stuff if there's anything that is interesting, because usually jury instruction stuff, it's important. Like the lawyers will argue about some stuff, but it's gonna be super boring. It's gonna be super like discussion of finicky wording stuff. So I don't know if I want to cover it as like a recap. If it comes up, if it matters, I will cover it. But otherwise, like if I don't do a recap of tomorrow's stuff, it's because I didn't think it was interesting. That's the long and short of it, right? It's And the thing is, a summary of the instructions will be watchable. We'll get a summary of the instructions when the judge just gives the instructions. That's the best way to do it. So, yeah.
So you're all at least going to compare notes by the end of the day today. And if you file anything additional, you'll let me know by email. And I'll plan on being back on the record with you all 1 p.m. tomorrow. Mr. Bloodworth, anything else today?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay. Ms. Richins, 1 p.m. tomorrow. The court is in recess. Thank you.
All rise.
I just got to go back frame by frame for one thing here. Nope, Bloodworth, get out of the way. She's got a lot of dangly. That's some really bright jewelry. I like the butterfly though. The butterfly is pretty cool. All right, so that's where things sit. They're done with all of the evidence. All of the evidence is in. We will not see any further evidence. We will instead, it's going to be jury instruction, gong show for, for the next whatever. We'll have to see. So, yeah, we'll figure this out. I see somebody saying there's a law nerd shirt in the audience. Don't do that. Don't wear my merch. Don't wear Emily's merch to court. Don't wear anybody's merch to court. We don't want to have a situation where some judge picks up on it, decides that this is in some way interfering with the process, decides to start, shutting things down. Don't. I mean, I can't control everybody and whatever else, but so all right. Anybody have any questions? We got some super chats here to go through. Can you post if you're going to stream or not on YouTube, not just Twitter? Yes, I can try to do that. What is it? All right. So let's have a look here. Katrina Bunny, that had me dying of laughter. Good stuff. Nancy Drewby, bring on the unicorns. Thanks for all you do. I'm not getting sponsored. I just like, it's the only IPA I like, believe it or not. It's a white IPA. I don't know what that means, but tastes good. So yeah. Lazy LCH, looking forward to watching this tomorrow. Love Robotic Runkle. I'm going to have to go back to the beginning of this stream and figure out what that was about. I don't know what an electric unicorn is, but enjoy. It's a beer. Corgi Grandma says, thanks for all the education you give and the laughs. Thank you. Mary Matilda May for the Timu Darth Vader voice. I don't know what you're talking about, but I'm going to have to find out. Donnie Not Wahlberg, extra caffeine needed. Fair. At least Zora got her favorite warm pillow. Zora has been insisting that I go to bed at a regular time now. And Nutty Beach, thank you for being a member for 12 months. That is awesome. Was it Morgan says, I mean, I respond the same way to Max, but never when we were on the record in a trial. And I used to be the Scot of our firm without the stash. Fair. PJ Wolf-Weimers, glad to be part of this community. Glad to have you here. The world wonders, why is she dressed like an early 90s pimp? I don't know. Meme Empress, is it supposed to be a silver lining on a partially sunny day or something? Maybe an egg or a dandelion? Lots of things I can call it. Very yellow. The official cat asks, what about a balaclava, Runkle? No face, no case. I don't think they'd let you wear a balaclava in court. But Mama Bets, why dress plain? You don't want jurors deciding anything based on how you look. And the way to try to keep them from deciding anything based on how you look is by looking like nothing. Like just, you ideally want to be something where their eyes just glaze over you and keep moving so that they're not watching you. You want to be visually boring. Whereas, they were anything other than, visually boring today. So she's dressed like someone pissed in snow. Fair. Girl named Joey, thanks for the update. I don't have time to watch all. Yeah, I can't blame you. Why did Kouri look like an egg? Because her lawyers missed the yolk. Harbinger of imminent death. All things considered, do you think she's getting a morally fair trial, including the nature of her representation? Nobody gets a perfect trial. I think she's getting a good enough trial, although I think it could be better. Aussie J, thanks for all your work. Her hard work, Runkle. Thank you. Vez from Quebec. The millennial with a Mac is her daughter. It's still not great. Radio Man S3. GIF is properly pronounced haif, from the Proto-Germanic word meaning to put similarly pigmented objects next to each other. I don't think that is accurate, but I think it is funny. Marvin CZ, thank you for 20 gifted memberships. Thank you. Tough Cookie says, I would wear Kouri's shirt, but I'm an older woman and don't want to be invisible. That's Ian's point. Yeah. Yes, I'm a Karen. Runkle Kouri's shirt looks like she dipped it in a bottle of mustard. Mustard is one of the friendlier things people have said about her shirt. Camilla says, explain the line for too prejudicial. It's a fuzzy line, right? It's a line that is, the judge is going to have to decide it on the, as it comes up. So it's not always clear. Tough Cookie, thank you for 10 gifted memberships. D. Peter, a textbook from school used a giant canary, flew me to the crime scene, and then vanished into thin air as an example of unreasonable doubt. Yeah. An alien could do it, is not a reasonable doubt. Stalin rose from his grave and committed the murder, also not a reasonable doubt, right? Debbie W, House of Cards, like Kouri's business and public image, one wrong move and it all comes crumbling down. Fair. I mean, other sort of classic, not reasonable doubts are like, some black guy did it and we don't know who. And you might be saying, Runkle, why are you saying some black guy did it? Well, because usually when the argument is like some unspecified dude might have done it, they usually argue it was a black guy because that's just how the system rolls. But, if you don't actually have any evidence to say that those are things, then, it's one thing if you've actually got another person being at the scene, right? Whereas if you don't, then it might be an unreasonable doubt. But if you've got some actual grounds to say that there's like some basis to say that the guy was there, like maybe you find fingerprints from that you don't know who they belong to, right? That might be a thing, especially if you find fingerprints from a guy you don't like, they can't identify, like on the murder weapon, right? It's like, maybe that guy did it. The guy whose prints are on the murder weapon. Maybe it was him. Maybe like a neighbor saw somebody climb through a door, right? Or climb through a window, right? Those things could could be a reasonable doubt out of what might have otherwise been an unreasonable doubt, because now there's some basis for it, right? So, yeah. Please explain prejudicial, because to me, if somebody did something, for example, Kouri punching Amy, why can't that come in? So Kouri punching Amy doesn't really have anything to do with this. And the thing is that you don't allow stuff that is just going to be evidence of bad character. So, I mean, let's pick a really awful example. My client is accused of punching his neighbor. And, that's the accusation, is that he walked over to the neighbor's yard and just smoked the guy in the face, right? That's the charge. But then when the police show up at his house, the guy has like bad pictures of children all over his walls. Like he has them printed out poster size. They're all over his walls, right? That detail is probably not going to be allowed in because it's insanely prejudicial, right? They'd say it would be like the jury's going to convict this guy because they're like, F this guy. But it has nothing to do with whether or not he punched the neighbor, right? So at that point, it's just too prejudicial. It has no probative effect. Now, he's probably also getting charged separately for having the pictures, at which point that is relevant information and would go in, right? But part of the reason why this isn't allowed is because of lengthy traditions of having court proceedings. And one of the things that they used to do is, like, let's say, a woman was murdered on the docks and nobody knows who did it, right? It was found, she's stabbed, and so what would they do? They would bring in some dude who lives on the docks and they'd bring up all the guy's past crimes. And all the guy's past crimes, they'd be like, so you robbed this person, you stabbed this other person, you whatever. And the jury would convict, notwithstanding that there was not a single iota of evidence that actually pointed to that guy as committing this crime, right? So you can't just like throw shit at the person. You can't just say this is a terrible person and therefore convict them. So, yeah. There's other sorts of things that like might just have nothing to do with the case. Let's imagine you've got a guy who's got Tourette's. And as he's getting arrested, he says the hard R N word like a dozen times. Well, he's got Tourette's. It doesn't mean anything, right? So presenting that to the jury of this guy said the hard R N word a bunch of times while he was getting arrested is going to sway the jury against this guy, but it doesn't mean anything. It's just leading the jury away from the truth, right? So, yeah. Pantoufel, thank you for becoming a member. Much appreciated. Morgan says, I didn't expect her to testify, but they're banking on the defense's case not being strong enough. That's a choice. Or the prosecution's case. It is a choice. I don't know if it's the choice I'd make, but it's the one they're making. Bird Mad Girl, thank you for signing up. Welcome aboard. Light Queen, thank you for 5 gifted memberships. Much appreciated. Beth Loves Things. Enjoy Mrs. Runkle birthday dinner. Zora Bed Shepherd. Zora has learned to listen for my streams winding down. And I can hear Zora outside my door because I think Zora is like, I would like to go to bed now. I would, it's snuggle time. Light Queen says, always love catching you in live. So much fun. So glad to have you here. Kurt Eaton, opening audio was awesome. TWK, beady. Okay. I'm going to have to check it out. Camper for Life. How do you think it could be better? Curious. If they have evidence, that would be helpful. Ohio Palm Mom, defense tried to do direct during the state's case. They did. They often didn't get the chance. Open the door. I don't know where Mrs. Runkle is, so actually I think she's out for a bit. Let me see if I can pull the Zora in. So yeah. Okay. Nope, Zora went away. Let me see if I can lure the Zora. Where's that bag of treats gone? I had a bag of treats in here. Here we go. We're going to try to lure the Zora. Zora! Zora! She might be napping. Zora! Treats! Oh. Dogs are out and Mrs. Runkle is home, so we're not gonna get to see the Zora at this point. So such is life. We tried. All right. Let's see. So what's the verdict? We don't have a verdict yet. Did I lure Mrs. Runkle? Mrs. Runkle is at the house, but all she said was Zora just went outside. So Zora is out there. So what did I hear? I don't know. I might have hallucinated it. Zora swoop instead. We could do a Zora swoop. Where's a good Zora swoop? I think I had a new Zora swoop. Here we go. Yeah. Any thoughts on the verdict? I think it's going to be guilty. I'm only about 70% sure that it's going to be guilty, but I think it's going to be guilty. So that's kind of the thought there. Somebody says, can we meet Mrs. Runkle one day? Mrs. Runkle has come to one meetup. She might come to another in future. So it's possible if you show up at a meetup that she might be there, but there's no guarantees. So yeah, maybe one day, but I cannot make any guarantees about meeting Mrs. Runkle. So yeah. What is it? What's the main reasons that makes it guilty? Walk the dog letter, the texts, the Google searches, those things. There's other evidence to make it possible, but yeah, you need to do more transition swoops again. You're not wrong. I need more swoops. I got to replace my swoops and so forth. So, all right. So we will, we'll wrap it up here, and I will see you guys, possibly tomorrow, possibly whatever, possibly Monday. If you are interested in Dungeons and Dragons stuff, I have a new video up on the Roll of Law channel. That's ROLL of Law. It is an interview with Kibbles Tasty, who is a famous designer of like homebrew and third-party content. We talk about licenses. We talk about airships and artifacts, which is this new product. We talk about AI. We talk about design of things, all sorts of things. It's about 90 minutes long. I think it's a really great interview. So check it out. Anyway, good night all, and see you when I see you. So good night.